Good morning. We'll get started in just a minute. I guess now it's that minute, less than a minute. Good morning. This is the time set for LUBA number 2025-069, Nedonna Development, LLC versus the City of Rockaway Beach. I'm Board Chair Zamudio. Board Member Basham is also present. Board Member Wilson is not present and either will not participate in the decision or will watch the recording of the oral argument and participate. Please mute your audio when you're not speaking. That will help with our recording quality. And I'm not aware of any pending motions before the board in this matter. Anything to bring to our attention? No, nothing from the parties. Thank you. Oral argument is a total of 30 minutes. Petitioner, you have 15 minutes and may reserve up to 5 minutes for rebuttal. Would you like to reserve any time?
Yes, please. I'd like to reserve 3 minutes.
3 minutes, okay. And I'll keep track of time here, but ask you also keep track of your own time. And just note that the watch or the timer that's on the screen is not exact. It's just there for reference. And respondent, the city, and intervener, you have 15 minutes to share for your response. Have you decided how you'll share your time?
Yes, the city will have 10 minutes and intervener will have 5.
Great, thanks so much. I will keep track of your time also, but ask that you also be mindful of your own time. So with that, petitioner, please state your name for the record and begin.
I'm Dean Alterman, Alterman, the attorney for the petitioner Nedonna Development.
Go ahead.
Right. Members of the board, this is a fairly straightforward issue, but with a weird procedural history. The city approved phase 2 of this old PUD. You remanded it. On remand, the city unanimously turned down the application to build phase 2. There are 2 really basic issues here. One of them is how to map a zone that is designed to protect wetlands, called the SA zone. And the other is when, if at all, does an approval expire? Under a poorly written condition of approval of a final plan. Let me talk about the zone boundaries first. First of all, in 2008, when the city approved this PUD, it found that the property contained 3.9 acres of R1 land. That's a residential zone that allows housing, and 2.33 acres of SA land. That stands for special area. It's a wetland zone that allows virtually nothing. The city had and still has a code provision that says when you want to develop something in the area of the wetland zone, the applicant shall go get a wetlands delineation and that will become the boundary. As I said, the city approved phase 2. The applicant provided a delineation. The applicant proposed the 20 lots in phase 2 to be exactly where the city had approved those 20 lots in 2008. There was no change to the plan other than rearranging the lots within that area. Oregon Shores, the intervener here, appealed the city's approval of that. You remanded the approval on 2 grounds. One of them was that you explained you had questions about where the SA zone was and how the city should apply section 3.080 sub 5 of its zoning ordinance. That's the one that talks about delineating wetlands. You told the city to address Oregon Shores issue, quote, regarding conflict with the SA zone as mapped on the city zoning map, or to adopt findings or interpretations explaining the city's apparent conclusion that the modified phase 2 approval is consistent with the SA zone. The city agrees, finding number 7 on page 7 of its decision, it agrees that you asked it to adopt findings that rely on the comprehensive plan and the 1992 zoning map, which is the most recent zoning map the city has, to determine how to apply that section. That's the only mention of 3.080 sub 5 in the findings. The city ignored your entire direction beyond that one passing reference. Instead of trying to reconcile its 92 zoning map with the property, it said, we will ignore completely our 92 zoning map. We will follow somebody else's zoning map that wasn't created until 2015, in this case, the Tillamook County GIS system. We will ignore our final decision that the PUD contains 3.9 acres of R1 land and 2.33 acres of SA land. Instead, we will change the zone to say it contains 4.8 acres of SA and only 1.4 acres of R1. That's important because that has a huge effect on the density of the project and how many lots can be built. And finally, it said, or didn't say, it simply ignored your direction for it to figure out what its code section 3.080 sub 5 meant. It doesn't refer to that. It doesn't describe how the process in its code for setting the boundaries of the wetland zone should be applied here. I don't want to be crude, but basically the city blew you off in your direction on this assignment of error. At a minimum, on remand, the city needs to adopt findings that respond to your actual instructions on how to apply 3.080 sub 5. It needs to figure out how to apply its official zoning map instead of adopting a zoning map of somebody else that looks nothing like the city's official zoning map, in a way that's consistent with its past decisions that specified the size of these two zones down to 1/100th of an acre. Instead, it's adopted a decision that makes about 8 or 10 lots illegal, 8 or 10 houses illegal by putting them in a zone, in its wetland zone, even though they're not actually in a wetland. That's in brief our first assignment of error. The city needs to deal with the fact that it's made a decision not based on its code, not based on its zoning map, not based on its past decisions. It simply ignored all of that in order, we think, to come to a conclusion that's politically correct inside the city. On the second assignment of error, here also the city pretty much ignored your instructions on remand. The question here is how to interpret a condition of approval of the original PUD and of the approval to phase the PUD in two sections, where the condition was in a section called Final Plat, and it read, I quote, "The developer shall complete the improvements within 1 year of preliminary plan approval." The word plan is important, unless an extension is granted by the city to complete the improvements. What the city granted was a deferral. The city said, now that you're doing this in phases, we want you to build, very logically, all the phase 1 improvements. We also want you to build a specified portion of the phase 2 improvements, streets, utilities. I think the phase 2 lots are all stubbed out for utilities already. The applicant did that 15 years ago. It didn't put any time limit on that. The city on remand said, even though that time limit in the condition says you have to complete these improvements within a year of preliminary plan approval, and even though we have already given you the final plan approval for the PUD, and even though you haven't, up until this proceeding, applied for a preliminary plan approval for phase 2, we're going to say you should have built these improvements before you had even applied for permission to do the subdivision. That, 1, it makes no sense. 2, it can't be right. 3, it's the city doing violence to its code. It's confusing plans and plats. In order to make its findings work, it had to say, we're going to pretend that tentative and final are the same thing. And they aren't. And it ignored your direction to evaluate how section 10.050, 1 and 2 of the code meant. It quoted it, and then otherwise it ignored you. I won't spend a lot of time on the third assignment of error. It's pretty straightforward. We raised that mainly because since the city chose to change its zone from its zoning map to somebody else's zoning map at the end of this process on remand, we need to preserve our argument that it doesn't make a difference because it approved 28 lots for this project. We will put the 28 lots wherever the city wants us to put the 28 lots. But it can't go back and retroactively try to attack its 2008 decision, which is exactly what it has done in this case. Thank you.
Any questions from the board? Board Member Basham, you're on mute.
Mr. Alderman, is the PUD designation a zone, an overlay zone of some kind in the city scheme?
The city was not quite clear about it. I think the best answer is that it is an overlay to whatever is underneath it, but it allows for it allows spreading out uses that otherwise would be constrained to lot size and areas. Our view is that once the city designated the entire parcel as a PUD, that it gave the flexibility to the applicant to put the 28 approved lots wherever the applicant wanted, subject to the city's approval, but that to that extent, especially because of the specific language that says you can have single-family housing in a PUD, it overrode the restriction of the SA zone as long as the total density is not exceeded.
I understand. Thank you.
Okay, now I think I'm confused by if the PUD is an overlay, but the underlying SA zone still applies. How then, what is the relationship between that PUD designation and the SA zone designation?
Let's suppose, Chair Zamudio, that this property consisted of two parcels. One of them was entirely SA and one was entirely R1, and they were being developed separately. The city would very reasonably say you get however many units are in the R1 that you get allowed, take it, divide by 5,000 square feet, I think is the number. That's how many units you get. In the SA, you can have recreational facilities of some kind, but you don't get any housing. Our view is that when the city said the SA and PUD together is exactly this much SA, this much R1, and your total density is limited to 28 units. It's actually higher. We didn't propose it to maximum density. We can put those wherever we want inside the zone, subject to the city's approval of the specific plan. In this case, we quite reasonably, back in 2008, it wasn't we, proposed putting all of the housing in areas that were outside the wetlands to somewhat less than the maximum density on lots that are smaller than the minimum requirement in R1, because we were able to count the rest of the R1 and SA land together. The city made a specific finding on how much there was, which has never been challenged until the prior appeal, actually.
Was there a determination in the 2008 decision where the boundary of the R1 and the SA zones is on this particular property?
As far as we know, records are incomplete. There was no specific determination. The areas involved seem to follow the areas of the wetlands delineation that was submitted in 2008.
Okay, thank you. And you'll have your full 3 minutes for rebuttal unless there's further questions from the board. Okay, so we'll turn to the city for your response. Please state your name for the record and begin.
Certainly. Good morning. My name is Lori Cooper. I'm an attorney with the Local Government Law Group, and I'm representing the city of Rockaway Beach. The city's decision on this application is supported by substantial evidence in the record and responds directly to the questions and issues presented on remand by this board. With respect to assignment of error number 1, the city erred in how it identified the location of the SA zone. The city had thoroughly reviewed the administrative record as well as testimony and argument presented on the underlying and present appeal, and reasonably determined that the Phase 2 lots proposed for development are within the SA areas. And as a result, the Phase 2 application was denied since the SA zone does not permit residential development. With respect to assignment of error number 2, that the final PUD plan approval did not expire in 2009, the city found that condition number 1, which required all improvements to be completed within 1 year, applied to the 2008 approval. And since those improvements were not completed, the final PUD plan expired in 2009. This is just summary, by the way. I'm going to get into more details in a second. With respect to assignment of error number 3, that residential uses are allowed in the SA zone, the petitioner failed to preserve this argument because it was not raised on appeal below or mentioned in the board's remand. But even if LUBA finds that this issue is preserved, the city's decision is supported by substantial evidence in its conclusion that the PUD designation did not amend or change those zone boundaries. So turning now to a little bit more detail on those arguments. Regarding assignment of error number 1, that the city erred in how it identified the SA zone. All the city did in this case was try to follow LUBA's direction, and LUBA had concluded that the SA is a base zone, and so the city followed the board's direction precisely on that issue and sought to answer this question: where is the SA zone located on the subject property? So first of all, what the city did, it reviewed the 2008 record and the present application to try to figure out precisely where those boundaries were. And as Mr. Altman mentioned, the records weren't great from 2008, but the city did try to figure this out. Contrary to petitioner's inaccurate assertion that the respondent gave no weight at all to its final determination in 2008, the city in fact reviewed the entirety of the record and to adopt pertinent findings on this issue. And after performing a comprehensive review into the history of this application, the city found that it could not rely solely on that original PUD decision, because in 2008, the Planning Commission did not specify the physical location of zone boundaries, nor did they reference a zoning map to make that determination. So the city couldn't rely on the final approval of the PUD, the 2008 approval, and tentative approval of phase 1 of the PUD to demonstrate exactly where those boundaries were. These are reasonable findings based on the record and are issued in conformance with LUBA's express direction in that remand. And there's no conflicting evidence on this point. Petitioner is incorrect that the city is, quote, collaterally attacking its own 2008 decision. The city has not revised or amended that 2008 decision in any way. And instead, the city thoroughly and reasonably reviewed the record to come to a very clear and obvious conclusion based on that 2008 record that the Planning Commission and the City Council failed to map that SA zone against the subject property in 2008. The property was mapped accurately in this current application. Pursuant to the board's remand, the city reviewed and analyzed accurate, up-to-date zoning information to determine where the SA zone boundary is located on this property. As mentioned, the comprehensive plan and zoning map are old. They have not been updated since 1992, and thus do not reflect zoning amendments since that time. And despite this outdated information, the city nevertheless attempted to overlay that 1992 map against this property to answer the questions related to the SA zone. So Mr. Alterman had indicated that the city didn't follow the board's direction and didn't try to do that. Well, the city did try to use that 1992 map, and those maps were just not adequate to accurately assess the zoning designations on this property. So what the city did was turn to its most reliable, consistent source of zoning information for city properties that it's been using, and that's the Tillamook County GIS map. All zoning changes from 1992 through 2015 are reflected on this map, and it provides parcel-specific zoning information. And this map has been publicly available on the city's website for quite some time. Without a legible, accurate representation of zone boundaries for this property, the city believes reliance on this GIS tool is reasonable and appropriate to answer the present question as to where the SA zone is on the subject property. And no other applicable city zoning map or any other evidence presented conflicts with this information. So using the best available data, the city found that the proposed phase 2 lots are located within areas mapped as SA wetland. And because that zone does not permit residential development, this application was denied. Petitioner raises a new argument that the city failed to analyze whether or how the PUD designation impacts the analysis of where the SA zone is located on the property. And the city maintains, as I mentioned previously, the city maintains this wasn't preserved, this issue, but in case the board does find it's preserved, the city did expressly find that this PUD overlay designation did not amend or change the location of any zone boundary lines. And this is consistent with the code language and actions of the City Council in 2008. Regardless of the arguable inadequacies of the 2008 process, petitioner's argument does not answer the question presented on remand to the city: in what zone are the phase 2 lots located? In other words, the PUD designation, or lack thereof in this instant, does not provide any answer or clarification to this mapping question. Turning to assignment of error number 2, that the final plan approval did not expire 2009. LUBA clarified some critical procedural facts in this remand, which the city adhered to and incorporated within its final decision in this application. First, LUBA clarified that the Planning Commission, when it originally approved the modification and final PUD plan in 2008, may possibly have erred in failing to require that the applicant submit a development schedule when proposing phase development, and in failing to impose a specific deadline on phase development as required by the city's development code. The city agrees with LUBA's understanding of this 2008 process and decision, whereby the applicant failed to propose a schedule for each phase when seeking modification of the original one-phase preliminary PUD approval. And accordingly, the city approved the modification and final PUD plan without such a schedule. The city further agrees with LUBA's conclusion on remand that if such errors were made in the 2008 PUD decision, then they cannot be remedied in appeal of the present decision, because the 2008 PUD decision is final and not subject to LUBA's review. And the final order in this application before us today reflects this reality. The 2008 PUD decision is treated as final, and it cannot be remedied at this point. Accordingly, the city reviewed the 2008 decision record to determine how best to reasonably interpret condition of approval number 1, a 2008 condition of approval number 1. And that is precisely what LUBA requested in its remand. The city intended the condition to apply to both phases. Therefore, the city found that the PUD has expired for failure to complete all those phase 2 improvements within 1 year of preliminary PUD approval. And these findings and the conclusions were included in the final order for the application at issue here. Finally, assignment of error number 3, as that's about single residential development being allowed in the SA zone. As stated previously, we don't think this issue has been preserved, but even if it has, there's no language in the Rockaway Beach zoning ordinance that authorizes development in the SA zone. And in fact, the zoning ordinance does not specify or provide any clarity on what the PUD designation actually does in practice. At most, the PUD designation may simply be an administrative tool to identify what lands are bound by a PUD decision. The city would look to that PUD decision to determine what applicable standards have been approved. So, based on this language, I mean, this is critical to understanding necessary limitations or allowances in a PUD overlay. And why would a parent zone designation be required unless the parent zone standards, like prohibited uses or density, et cetera, why would those be required unless they applied to that PUD area? The PUD designation does not override the parent zone's permissions or limitations. So based on this plain language of the city's code, as well as thorough review of the 2008 decisions, the city reasonably found that approval of the PUD application and the PUD overlay designation did not amend nor change location of any zone boundary lines. This critical question presented to the city on remand was identified with particularity where the SA zone boundary lies on the property to determine whether those phase 2 lots could be developed in accordance with the zone's limitations. And identification of the PUD designation here, even if the Planning Commission and City Council in 2008 failed to specify the PUD designated area with the SA zone on there, doesn't answer any of these questions. So ultimately, regardless of whether petitioner is correct on this point, the question of where phase 2 lots are located is still the most important question to answer. And that's because the SA zone is a base zone, as LUBA stated in its remand, with its own development standards and limitations. So to conclude, the city's decision is supported by substantial evidence in the record and responds directly to the questions and issues presented on remand by the board. And I welcome any questions. Thank you.
No questions from the board for the city. We'll turn to intervener for their argument.
Thank you, Eric Riston, on behalf of interveners, Oregon Shores Conservation Coalition, and North Coast Communities for Watershed Protection. The primary issue I want to focus on is what we think is petitioner's total failure to challenge each of the city's bases for denial. Like we've talked about, the city had 2 bases for denial here that stem from the 2 assignments of error that LUBA remanded in the prior appeal. Those are first, that the development was proposed within the SA zone, which doesn't allow residential development. And second, that timing condition of approval from 2008 caused those earlier approvals to expire since the improvements for phase 2 were not made within a year. We think that petitioner failed to state a case for remand or reversal regarding that second basis for denial in his petition for review. Petitioner in its opening argument here just added some new arguments and actually started to talk about the condition of approval 1 for the first time here at oral argument, which is pretty clearly not allowed under LUBA's precedent. But if you read the petition for review, it doesn't really talk about condition of approval 1 at all. The second assignment of error, which is maybe the assignment of error that gets the closest to that basis for the city's denial, focuses instead on a couple of Rockaway Beach ordinances that are not actually relevant to the city's findings, or not in the city's findings. We haven't argued, nor has the city argued, that they were controlling here. I think if you really read that second assignment of error and read it closely, and then read it compared to the city's findings on that actual basis for denial, you'll see that there's just a total mismatch, and petitioner really fails to get at the actual reasoning that was in the city's findings regarding interpreting condition of approval 1. We think that LUBA's case law is clear that in order to challenge a local government's basis for denial, the petitioner actually has to address the local government's actual reasoning and point to the relevant approval standards or local enactments, which is not a particularly high bar, but we think the petition for review really fails to do that here by not even mentioning condition of approval 1 or getting at the actual reasoning in the city's interpretation. And for that reason, because this issue is also an independent basis for the city's denial, we think that mistake is fatal to the petition for review, and that LUBA really doesn't need to look any further than that issue to resolve this case. Turning to the first assignment of error, I want to make a quick point, which is that regardless of the city's reliance on the online mapping tool, the city showed in its findings that the property is within the SA zone on its 1992 comprehensive plan map. That's shown really clearly in the maps that are created by the city that overlay the property boundaries onto that comprehensive plan map. We included a copy of that map in our brief. Apologies, I referenced red squares on the map and then printed the brief in black and white, but hopefully the maps are still clear. So we think that because that property, the city showed the property is clearly within the SA zone, without even using the online map, that the city's interpretation of that finding was reasonable and should be upheld, even if the board has concerns about the use of the more detailed online maps that petitioner focuses on in its arguments. Finally, on the third assignment of error, really quickly, LUBA remanded the 2 assignments of error in the previous appeal to the city to consider with pretty specific instructions. Petitioner chose not to participate in that prior appeal and now makes arguments that could have been raised in that case regarding wholly new provisions of the Rockaway Beach zoning ordinance that were outside the scope of LUBA's remand, which the city limited arguments to. For those reasons, we think that the arguments in the third assignment of error are totally foreclosed and not preserved here. If there's no further questions, I will wrap up here.
Thank you. No questions from the board, so we will return to petitioner for your 3 minutes for rebuttal.
Right. Thank you, Chair Zamudio. To take these points really quickly, first, despite the argument of the city, it did in fact ignore its zoning map. Its conclusion that the Tillamook County zoning map controls the city zoning is at variance with its past decisions and with its own zoning map. The shapes are nowhere near the same, and under the city's interpretation, 6, 8, 10 houses in the area are all inside the prohibited wetland zone. If the city is arguing that the PUD approval itself has expired, which is what I heard council say, then it's also making every single house on those lots illegal, which seems very inconsistent because they're all on substandard lots. That is not a rational decision. With regard to preservation of issue number 3, to respond to Mr. Riston's point, when this appeal went up the first time, this property in the city's view was properly zoned to allow the development. Only after the appeal came back did the city decide the zoning boundaries were something other than how the city had evaluated the first time. That's an issue, if you will, that the city created on remand by changing the zoning of the property to follow Tillamook County's online map. Whether it is preserved or not the first time around, it's based on a new fact that didn't exist in the first appeal. Otherwise, we think we have been very clear on our appeal. The city has to take account of its past decisions. It didn't do that. The city has to take account of its own zoning map. It chose to ignore that and adopted something with a different shape. The past decision took the area of the 2 zones down actually to an exact number of square feet. Record 1444. The city doesn't deal with that. For all of those reasons, LUBA should remand this decision to the city to adopt findings that reflect the facts as they are and not as the city would like them to be. Thank you.
Thank you. That will conclude oral argument. The statutory due date for our decision in this appeal is January 26th. We'll ask that the parties agree to an extension so that we issue our opinion no later than February 9th. Is that okay with these parties?
That's fine.